Maintain status quo till January the 17th. That's the order of the Federal High Court in Abuja after its decision to stop the arraignment of Justice Onnoghen.
That's correct. Well, the ruling on two separate ex-parte applications where the court ordered that that no steps should be taken in respect of the trial at the Code of Conduct Tribunal until the parties are expected back in court for the hearing of the motion on notice.
We have joining us in the studio now a lawyer, GT Ogunye, to give us a perspective and understanding into what is really going on. Good morning. It's good to see you.
Good morning.
Good morning. Yes. Right. I read your write-up on this issue, and one of the key words you said that this whole taking the Chief Justice to his arraignment is illegal and unconstitutional. Now, make us understand, because you quoted Nganjiwa versus the Federal Republic of Nigeria, where the Court of Appeal upheld that no serving judge can be prosecuted while in office and all of that, even though it's still being contested at the Supreme Court and all of that. Make us understand why this is unconstitutional when the substance of the case is not strange to Nigerian law.
Well, let me start off by saying that what we're discussing today in Nigeria is a very sordid affair. It's not a matter about which I'm proud as a legal practitioner. Every Nigerian should be bothered about this kind of allegations. And so I state upfront that this is an unfortunate matter. Now, that said, let me quickly say that the Nigerian judiciary is not about corruption. The Nigerian judiciary is known for excellence, industry, indeed, a kind of professional regimentation that is like that of the military. Now that we're talking about the Armed Forces Day, judges practically don't have a life. The right judgments, the age in the process, and is what they sign up to. So, yes, there's corruption or corrupt practices in the judiciary, but this is not the major characteristic of the Nigerian judiciary. And so, because when you discuss something like this, it's possible for one to fall into error, thinking that, oh, all the judges in our judiciary are corrupt. That's not the case. Now, my view is that serving judicial officers can be investigated, arrested, even prosecuted and tried and convicted while they are still serving. The law provides for it. There are provisions in the Criminal Code and Penal Code that allow it. There are provisions in the ICPC Act that allow it. Public servants serving judicial officers can indeed be arrested and prosecuted. And indeed, that was why the EFCC filed that charge against Justice Nganjiwa in the case of FRN and Nganjiwa in the High Court. An objection was raised at the High Court by the criminal defendant, Justice Nganjiwa in that case, to the fact that being a serving judge, unless and until it was dealt with by the NJC in a professional manner, via a disciplinary process, that it could not be arraigned before a court. Of course, the FCC said that that's not the law, and that objection was overruled. He then appealed to the Court of Appeal, Lagos Division. And the Court of Appeal, Lagos Division, held now in Nganjiwa and FRN, reported in 2018 for Nigerian Weekly Law Report, part 1609 at page 301, particularly at page 343 and 349, that as far as their own understanding of the law is concerned, without the NJC first treating the case of misconduct, which may constitute a criminal offense First, that such a judge could not be arraigned in a court of law and tried. In other words, their position in that case was that that judge must have been tried by the NJC for misconduct, which may constitute a criminal offense, stripped of his judgeship, and then brought before a court. Their thinking is that it is indecent, it's not appropriate to have a serving judicial officer arraigned before a court.
Let me interrupt you, Mr. Onnoghen. I've met a couple of lawyers who do not agree with that appellate decision, but are bound by it. Only yesterday we had some lawyers who reacted and gave their own take on that. Everyone is bound by that decision and expects that the CCT should also fall under that line. But what's this about? You stated earlier that the judiciary or the bar is known for excellence, but yet we are seeing the NBA president also standing trial for corruption, and now we are having our own CGN also having to answer to these crimes. By the way, the judiciary and the bar, we saw the solid defense and solidarity they gave to the CGN yesterday with a number of SANs and lawyers who came to the court. But what's this about, really? Is it an attack on lawyers, on judges? What do you think?
No, it's not an attack on the judiciary. It's not an attack on lawyers. You know, when you say the NBA president is facing a criminal charge, you know how many lawyers you have in Nigeria? How many of them are facing criminal charges? Right. So if you take the statistics, we're talking about a minuscule number here. Okay. And so my insistence is that you can't use that to then say, oh, all the lawyers are corrupt, or even use this one to say that all the judges in Nigeria are corrupt. It's bad that at the apex, the CGN, who is the head of the third arm of government in Nigeria, is being arraigned. It's unprecedented. It's never happened in the history of this country before, and so it's solid. But that said, you can use that as a basis to then pivot and then allege generally that judges in Nigeria are corrupt and that all this is an attack on the judiciary. They are partisans, political parties, and even some lawyers who may say that, oh, the judiciary is under attack. I don't think so. I've said that I don't agree by that decision. That decision is on appeal at the Supreme Court. By the way, I'm part of the team that is appealing that decision at the Supreme Court. And I know...
Not as the EFCC team.
I'm part of... You know, there's a team, Federal Republic of Nigeria. It's a Federal Republic of Nigeria case. EFCC is prosecuting.
For the country.
Following what happened at the Court of Appeal, that team was expanded. A senior advocate of Nigeria was brought in. Some other lawyers were brought in to form a more formidable team. Because a very important matter, that issue is about our constitutionalism. It's about democracy. It's about whether the scope of immunity to public office can be expanded beyond Section 308 of the Constitution that specifies that only 4 executive officers in the executive branch of government enjoy immunity from prosecution and all that. Not even from investigation. Because, as you would know, in the case of Fayemi and IGP, you know, concerning Bola Ahmed Tinubu when he was governor, you know, the Supreme Court has said, no, even for those who enjoy immunity under Section 308, you can investigate them and perhaps preserve an otherwise perishable evidence until he drops the toga of immunity, and then you pounce on him and all that. Everybody in Nigeria, every public officer can be investigated. Those who enjoy immunity under Section 308 may not be prosecuted for that tenure, but they can be prosecuted later. Now, what this decision is saying is that they cannot even be investigated by anti-corruption agencies unless they've been dealt with by the NJC, let alone being prosecuted. And so for me, what I think the judiciary or the Court of Appeal tried to do in that case was to grant an immunity to the judiciary beyond what the Constitution has stipulated. Okay. It was a forced interpretation of the Constitution. Decided Section 158, Section 153, Section 292, Paragraph 21 of Part 1 of the third schedule of the Constitution. All this, there is nothing in those provisions that specifically states that judicial officers who are serving cannot be investigated for committing crimes and prosecuted.
And it's the apex law, so to speak. All other laws fall under it.
Exactly. So what I saw in that judgment was a protectionist judgment. And I think that we can discuss all this. In that judgment, allusions were made to the fact that even the executive branch of government, when some of them are accused of criminal offenses, felt they will set up an arbitrary panel. We had it in the grass cutters case. Exactly. We have it in all the other cases. We have it in even the arms scandal case. There was
even in the military.
In the military. So they are now saying, no, you are rubbishing the judiciary. Don't do this and all that. That may be desirable. Indeed, that may be desirable. But it is the legislature that amends the law. The judiciary interprets, and in discharging the power of interpretation, the judiciary is not expected, no matter how liberal that interpretation is, to then supplement and then start reading into the Constitution what is not in the Constitution. So I see it as a protectionist thing. So you are harassing us and all that. So you are not being fair. So we use our power to also protect ourselves. That matter is on appeal. We won't discuss the merit. We can't discuss the merit. However, it is the law. And that's why I opined in that intervention, article, probably by Premium Times, that no. Step this down. Whatever petition you have, submit it to the NJC. That is the law now. You may disagree with it, you are banned by it. And Section 287 of the Constitution says that everybody, every person and authority in Nigeria is banned by that decision. There are some lawyers who have said, no, there are some exceptions. Even in that judgment, it is said that if murder, arson, manslaughter, all such offenses are committed, but if you read the judgment as a whole, you will see it's clear. And when I said page 349, because I brought it, it's here, okay. And I just permit me to just quickly,
go ahead.
Do it. And it says, NJC is the sole body. This page 349. NJC is the sole body empowered by the Constitution to determine allegations of misconduct against judicial officers, even on criminal allegations of bribery and corruption made against its officers. The NJC is created by the Constitution to solely regulate affairs of the appointed judicial officer without interference from any authorities. It is only and only when the NJC has given a verdict and handed over such judicial officer, removing his toga of judicial powers to the prosecuting authority, that he may then be investigated and prosecuted by the appropriate security agencies. What the EFCC and the anti-corruption agencies have done since this judgment was to creatively interface with the NJC. And I must say that under the CJship of Justice Onnoghen, is the such wonderful collaboration. Even after the judgment, what do I mean? Immediately after the judgment, the FCC and the anti-corruption saying that, okay, this is what the court is saying now. Right. So all those cases that were in court, they then presented petition before the NJC. The officers were now appearing before the NJC panel to give evidence and all that. And that's how some of those judges, whose cases were then compromised because of this judgment, whose cases were then withdrawn and stepped back, got fired.
What category?
On the recommendation of the NJC. Yeah. And so we don't need
but
to
what
mention
category does
now.
the Justice Ongute case fall under? Because that case went to the Code of Conduct Tribunal, and we saw the chair then, hands off.
Because of this authority. And that's why I'm saying that, you see, lawyers can dance around and all these things. I'm a very, when it comes to the issue of law, I state it the way I know it best. If the intention was to force the issue, maximally scandalize the office of the CJ and expose him to public ridicule and overwhelm him, I saw that he would then resign. The rule of law is that you don't use court processes to achieve such end. That would be tantamount to an abuse of court process. More so because when the authority is very clear, So unless you have this decision overruled on appeal, it's a solid road block. And that's why it's being appealed by the federal government of Nigeria. So if the federal government of Nigeria knew that the judgment was of no consequence, it won't be appealing it.
So based on the prescription now, or the precedence from the appeal court of appeal, it means that he has stripped the CCT of the jurisdiction to hear this case now. Are we expecting that, even though we don't want to be preemptive, but are we expecting that the CCT by itself, knowing what the law has said, will recuse itself from this case?
Well, that's a possibility. Okay. But let me just say generally, you know, we've had a comedy of errors here, which is sad. First, the CJN allegedly didn't make
yesterday.
Didn't make certain declarations, which formed the fulcrum, the basis of this charge. And he said, I forgot, although people are saying that he had not made that statement, openly. So that's a kind of error. And then you have the federal government of Nigeria filing this charge at the CCT. It's an error. And then later, in response thereto, some lawyers went to the Federal High Court or National Industrial Court to obtain orders and all that. You don't do that. And that was the same thing that people did in the Saraki's case. You recall that when Senate President Saraki was being brought before the CCT, his lawyer went to town, started forum shopping, went to the High Court to be obtaining order to restrain. And on that occasion, we told them, the CCT is a special tribunal. Is vested with special powers. Is ranked as a high court. That's the ranking. They are on the same level. So it's not an inferior tribunal whose orders or whose proceedings, whose jurisdiction can be arrested by a high court.
So the industrial court, the high court,
don't do this.
They're all on the same level.
Don't do this. Okay. As a matter of fact, in some respect, the judges of the CCT have a better security of tenure than even the CGN. To remove any of them, you will need the concurrence of the two houses of the National Assembly. Not for the CGN. It's just the concurrence of the Senate alone to remove him. So it's a so don't do this. But now I think that when people are desperate for reprieve, you have this.
So
in Abia State, we saw it. Oga and the governor, Ikpeasu, I think, yes, it's Ikpeasu in Abia State.
Yes.
There was a federal high court pre-election matter that said that he should be removed as the governor and all that, over tax declaration and all that. And then people started going to court, including a high court in that state, to obtain an injunction. So when things like this happen, that's an error in my view. What they need to do is go before that tribunal, raise this issue. If the tribunal overrules, it snakes the way up the ladder, up to the Supreme Court that will decide the matter. That's the rule of law that I know.
Let me ask you a quick question. If you were the CJN, would you have attended the trial yesterday?
Well, I'm not the CJN.
Right.
So I don't know whether...
Because the legal lawyers were saying let him go, some were saying let him not go, and then we saw him not attending.
Let's look at it this way. Law is a very interesting subject. Yesterday, it was said that there had not been proper service, that the CJN had not been served. And so that he directed, when they were going to serve him, directed his PA should remove. Right. So there was no personal service. His lawyer raised that objection. So without proper service, what will the CJN have been responding to by appearing in court? So it's a rhetorical question. So technically the CJN could have said, I have not been properly served, so I am not obliged to appear before the court. So that would not then mean that he's hearkening to what his co-ethnics are saying in the South, saying that don't go, don't treat it.
So you're saying, I know the law, the bailiff or whoever now came to deliver the court papers to me, and then I direct my PA to collect for me on that day. So he was there and didn't collect
That
the
was
papers.
what was alleged.
Okay.
But what was important was that there had not been proper service, and the CCT acknowledged that and directed that there be a fresh service, so that the matter could commence. So essentially, the matter had not commenced. We just had preliminary skirmishes yesterday. And so there will be a preliminary objection, I presume, and then the matter will be argued, and then it will go all the way to the Supreme Court. But I hope that all said, we'll take pain to go through all this. There is the likelihood that Nganjiwa and all that, even after the Supreme Court must have ruled on it one way or the other, won't have had the last of it. It's going to be like the case in the United States, Aaron Wade, which talks about women's rights and all that. So each time you see schism between the Republicans and the Democrats on who should go to the Supreme Court, whether they are going to overrule Aaron Wade, things like that, and many such cases. So I presume that in Nigeria, this debate will continue on whether judges can be insulated from investigation, criminal investigation, and prosecution while they were serving, beyond what the Constitution has expressly provided. I know that many lawyers out there, including jurists, judges, will be chuckling. We are the interpreters of the Constitution, so you want to embarrass us, so and all that. But I've read the Constitution very well. I've seen it. It's a protectionist judgment, but that's what the law is
at the moment.
All right. Talking about yesterday, we had a large contingent of lawyers, over 80 lawyers, and about over 40 senior advocates of Nigeria at the CCT in solidarity. Would you say it is just a solidarity to the CJN, or it is a move to protect the judicial arm of government to have that number?
It was a mockery of legal representation.
Oh.
And you know, a lot happens in our country, and so we just allow it to pass. Under the Legal Practitioners Act, a senior advocate of Nigeria has certain privileges. He is not expected to appear in court alone. And so he is expected to appear in court with juniors. It is not therein stipulated or anticipated that we will now have a situation whereby senior advocates will be leading senior advocates, you know, just to make a show, because it's only one person that will speak. So if you wanted to have a conference or a strategy session, you didn't need to come to court to do that.
That has been the tradition.
And it is of recent development. It's of recent development. So for senior advocate of Nigeria coming together, 45, Ricky Tafa was to be arraigned, 100, Paul Usoro, Saraki, then Bola Tinubu at Code of Conduct Tribunal, you know.
In this case, we called it a solidarity.
If it is solidarity, you know what happens? Let one senior advocate of Nigeria appear with juniors, let the others step out. They will be in court to watch proceedings in solidarity, but their name will not be mentioned in that case. So we've had all these things happening, and that's why I use the word comedy of errors, you know, all over the place. So it's one person that will speak. You know that in the Ricky Tafa's case, the judge, you know, said, even openly in court, said, what is this all about? Is it to intimidate the court, or what is it all about? You know, right. And I think that we'll have to deal with all these issues in a way that the health of the judiciary will not be destroyed. It's important because it's the third arm of government.
Absolutely right. Important.
Onnoghen, we thank you so much for giving us insight into these explanations for us to know how these things are playing out. Thank you so much.
Always enlightening. Thank you.
Right.